Good afternoon, distinguished ladies and gentlemen. It is my pleasure to welcome you back for the second session of our conference for 2021. Would also like to welcome all those who are joining us online. And this is the concluding part of the event for today. For the second session, the theme is the role of insolvency practitioners. The role of insolvency practitioners, and the coordinator for today is the beautiful Kende Oyebade, who will be assisting us with coordination, and the moderator for today is Ms. Efosa Ewere. Ms. Efosa Ewere, please put your hands together and make welcome Ms. Efosa as she takes her place on the stage. I would also like Mr. Oluwakemi Balogun, SAN, to please join her on stage as one of the speakers. Please put your hands together and make welcome Mr. Oluwakemi. And the second speaker for the day, please put your hands together and make welcome Mr. Olanikpeku Orewale, FBR, as he joins them on stage as well. Would also like to recognize our third speaker, who will be the first speaker for the day, in the person of Alhaji Garba Abubakar, Registrar General, CEO, Corporate Affairs Commission. Please put your hands together for him. He's joining us online. Over to you, ma'am.
Good afternoon, everyone. You're welcome to today's session, the second session for today. Today, we'll be discussing the role of the insolvency practitioners, and we have with us physically Oluwakemi Balogun, SAN, and Mr. Olanikpeku Orewale. We would also have with us, joining us virtually, the Registrar of the Corporate Affairs Commission, Alhaji Garba Abubakar. The essence of having this discussion is to help those who have chosen to be insolvency practitioners to seek clarification on the issues bordering their practice in Nigeria. Particularly well chosen are the speakers. We have the regulator, the CAC Registrar General, and we also have practitioners who are seasoned in this practice to give us an insight as to how we can practice with the enactment of the Companies and Allied Matters Act 2020. So beginning with this conversation today is the Registrar General of the Corporate Affairs Commission, who is going to join us virtually. He's going to give us an insight on licensing of insolvency practitioners. You would all agree with me that to practice now with the enactment of CAMA and introduction of Section 704 to 709, there have been different criteria on who is now eligible to practice as an insolvency practitioner in Nigeria. And also there are clarifications that have been provided by the CAC on how and when they choose to regulate or, things that has to bother about their license. So I don't know if we have the Registrar General now. But before...
Yes, thank you, I'm here.
Okay, Thank you so much. So before the Registrar General gives an insight on the licensing, I would want to read the citation so that we get familiar with who our regulators are, or who is heading our regulator, or regulatory body, rather. So Alhaji Garba Abubakar was appointed the Registrar General CEO of Corporate Affairs Commission, 7th January 2020. He obtained his law degree from Ahmadu Bello University, Zaria, and was called to the Nigerian Bar in 1989. Until his appointment, he was director in charge of compliance litigation at CAC. He had earlier served as the special advisor to the former Registrar General between 2010 and 2017. In that position, he championed the reforms on ease of doing business, particularly in the areas of electronic registration, consolidation of registration forms, integration of the CAC registration portal with the FRS stamp duty portal, reduction of registration fees, direct registration by first directors or subscribers, as well as the creation of public search window, which provides free information on the public on all entities registered by the CAC. Alhaji Abubakar presently serves on the board of the FIRS, that's Federal Inland Revenue Service. He is also a member of the Financial Services Regulation Coordination Committee, the National Steering Committee, Open Government Partnership, and the Governing Council of the MBA section of Business Law. He has served on governing boards of the EFCC and Oil and Gas Free Trade Zone Authority. He was involved in the design of the critical reforms in the financial sector and corporate space as members of various committees. Some of these committees include Legal Framework Subcommittee of FSS 2020, National Steering Committee on the Establishment of National Collateral Registry, Legal and Enforcement Subcommittees of the FSRCC, National Steering Committee on Harmonization of Codes of Corporate Governance, Inter-Ministerial Committee on AML, CFT, Inter-Ministerial Committee on Ease of Doing Business, FSRCC, Workstream 4 on Early Intervention Measures, and Crisis Management Continuum on Systemic Financial Crisis in Nigeria, as well as in-house committee on the reenactment of the Company and Allied Matters Act. So please, we welcome the Registrar General, Alhaji Garba Abubakar, to give us an insight on licensing of an insolvency practitioner. Thank you.
Thank you so much. Good afternoon, all. And thank you for the opportunity to speak on licensing of insolvency practitioners. I must thank the president of BRIPAN and all the council members for finding me fit to talk on this topic. Until CAMA 2020, there were no prescriptions as to who may act as an insolvency practitioner. The CAMA 1990 was silent on that. But with the enactment of CAMA 2020, Section 706 of the law, Section 868, defines an insolvency practitioner as a legal practitioner within the meaning of the Legal Practitioners Act, or a member of the Institute of Chartered Accountants of Nigeria, or such body, or such other professional bodies of accountants as are established by an act of the National Assembly. This definition is without prejudice to the powers of the Commission under Section 706 of the Act to, by instrument or order, recognize any other body, any other professional body for the purpose of qualification to practice as an insolvency practitioner. However, the Commission may only recognize such other body if the body regulates the practice of a profession and maintains as well as enforces rules for securing that its members are permitted by or under the rules to act as insolvency practitioners and are fit and proper persons to act and meet acceptable requirements as to education and practical training. The scope of definition of an insolvency practitioner in the Act only deals with persons that act either as liquidator, provisional liquidator or official receiver, administrator or administrative receiver, or receiver and manager, or as nominee or supervisor of a company voluntary arrangement. As we all know, the traditional legally recognized areas of insolvency practice before now was only receivership and liquidation. The CAMA 2020 has widened the scope with the introduction of company voluntary arrangements and company administration. By the provision of Section 705 a person is only qualified to act as an insolvency practitioner if he has a degree in law, accountancy, or other relevant fields from any recognized university or polytechnic, has not less than 5 years post-qualification experience in insolvency matters, and is a certified member of BRIPAN or any other professional body recognized by the Commission and permitted to act by or under the rules of that body, or is accredited by the Commission. For the first time, the law has given the Commission the power to accredit insolvency practitioners. The law has also given the Commission the power to prescribe additional qualification to act as an insolvency practitioner and to designate anybody to be recognized as a professional body for the purpose of insolvency practice. As some of us may recall, the Companies Regulation 2021 has widened the qualifications of persons that may practice as insolvency practitioners by recognizing members of the Institute of Chartered Secretaries and Administrators of Nigeria. The Commission did that in line with the mandate under the law. But mere membership of BRIPAN, or the mere fact that you are a legal practitioner, does not automatically qualify you for licensing as an insolvency practitioner. By Companies Regulation 2021, in addition to being a member of the Nigerian Bar Association or being a member of the Business Rescue and Insolvency Practitioners Association of Nigeria, or Institute of Chartered Accountants of Nigeria, or Institute of Chartered Secretaries, or Association of National Accountants, one must show that he has at least 5 years experience in insolvency practice. And either in his position as a liquidator or as a receiver. When this requirement was introduced, we had a lot of issues, a lot of complaints from practitioners on the ground that some of them were not directly appointed as receivers or managers, but they had worked under a receiver. So we had to modify our guidelines to accommodate persons that have participated in any receivership or liquidation in the last 5 years, provided there is a confirmation by the principal or the law firm where the person is confirming that he has actually been involved in any liquidation or receivership process in the last 5 years. In addition to that, it's only BRIPAN that presently conducts a certification training on insolvency practice. We are aware that other professional bodies, particularly the Nigerian Bar Association, is in the process of introducing a similar training. But until then, anybody that doesn't have the requisite experience must provide evidence that he has undergone that form of training. Why this is necessary is because, as I have said, the law has widened the scope of insolvency practice to accommodate voluntary arrangement and administration. These are two areas that focuses mainly on the rescue of the business as opposed to the traditional receivership and liquidation, where the primary focus was actually to see to the end of that company. So because of that, to qualify to act as a receiver, as an administrator, or a supervisor under a voluntary arrangement, one requires some form of experience or training to enable him to discharge that role efficiently. And without any evidence of previous participation in a receivership or liquidation process, it is mandatory that such a lawyer or accountant or a member of the Institute of Chartered Secretaries must provide evidence to the effect that he has been certified as at now by BRIPAN. So until such a time that we are satisfied with the curriculum that will be issued by the Nigerian Bar Association and the Institute of Chartered Secretaries and Administrators or the Institute of Chartered Accountants, any other member of such professional bodies that is applying without the requisite experience will not have any choice than to approach BRIPAN for membership. People will be wondering, because we have received a lot of knock in that area, that we are trying to create a monopoly by recognizing only BRIPAN. But what we have been telling people is we are simply following the letters of the law. Although, if you follow strictly the definition of Section 706 that talks about being a lawyer or a chartered accountant, subsequent provisions that recognizes membership of BRIPAN and the fact that the commission can prescribe another form of qualification or professional qualification to qualify as an insolvency practitioner has given us the authority to regulate that area of practice. We are at the verge of coming up with additional guidelines and regulations that will cover matters relating to, in addition to accreditation of insolvency practitioner appointment, the administration of the different insolvency resolution options, standard contents of documents and documentations to be provided, standard forms for notifications to the commission, the content of the specialized trainings and capacity building for insolvency practitioners in collaboration with professional bodies and faculties, the requirement for bond or indemnity from insolvency practitioner. The draft is under consideration by our management. As soon as that is done, we'll expose it to BRIPAN and other key stakeholders. We've also written to His Lordship, the Chief Judge of the Federal High Court, advising him on the need to enlarge the prescribed framework for insolvency to accommodate issues relating to administration of companies. Because under Section 548 and 732, the Chief Judge is vested with the power to make rules for winding up under the Act. So this letter was delivered yesterday, and we have offered to provide any technical assistance or support in that respect. So, as I have said, for the first time, the mere fact that you are a lawyer, an accountant, or chartered secretary does not automatically qualify you to practice as an insolvency practitioner. You must be licensed, and the commission has introduced an accreditation system where a one-off fee of 50,000 is paid with provision for renewal every 2 years. The renewal is done at no cost. And to qualify for renewal, one must provide evidence that he has undergone some form of continuous training in the area of insolvency practice. So this is very key. I'm aware that BRIPAN, as one institution, has institutionalized that form of training. Other professional bodies that are planning to introduce certification system must necessarily have a form of continuous training for their members. So these are my notes on this issue, and I'll be glad to respond to any question afterwards. Thank you so much for having me.
Mr. General was very, very clear and deep in that discussion. So now with moving on to the next speaker, Mr. Agwunobi Chioma, SAN, who is a practitioner in this field. He's going to be giving us the perspective from the practitioner's angle. That's practical skills required of an insolvency practitioner. Mr. Agwunobi Chioma, SAN, is one of the leading authorities in corporate insolvency in Nigeria. He is the senior partner of Oluwakemi Balogun Legal Practitioners, the foremost commercial law firm with a bias for insolvency in Nigeria. He was called to the Nigerian Bar in 1991 and his LLM in 1996 from the prestigious University of Lagos. He was appointed Notary Public of Nigeria in 2005. He is a double merit award holder of the MBA and was elevated to the rank of Senior Advocate of Nigeria in 2014. His depth of knowledge of the practice of insolvency is unparalleled, having undertaken by far scores of very complex receiverships and liquidation exercises within the Nigerian market, and has written and delivered many papers in this technical field. So I'll welcome to the podium the learned silk Oluwakemi Balogun to give us tips on skills we require to practice insolvency in Nigeria. Thank you.
Good afternoon, everybody. Okay, so I will share my little thoughts on insolvency over time. So I've put down something, and I hope that you will share the slide. Let me first say that, go to the next slide. The next slide says, play by the rules, but be veracious. And that was taken from Phil Knight. Insolvency is not for the faint-hearted. And I'm going to repeat that. Insolvency is not for the faint-hearted. Now, you are coming over to take somebody else's company. You must be prepared. And you must have guts. And that is just the simple truth. So let me leave that there. Then in this paper, so in this presentation, I look at definition of pandemic because we are under pandemic. I look at the insolvency provisions under CAMA 2020. Then I will also look at who is an insolvency practitioner. Then I will look at receivership and liquidation in Nigeria. I'll look at who's the receiver manager. I'll look at the duties of a receiver and manager. I will also look at who is a liquidator. And then on the concluding part, I will dovetail and zero in on practical skills required of an insolvency practitioner when carrying on his duty. That is the concluding part. So briefly, the effect of, the effect of the pandemic over is apparent to virtually all of us. So you see companies tumbling down, results and targets not being met. The resultant effect of that is that many companies might not be able to meet their financial obligations to their creditors. And the resultant effect of that is that you are likely to have many companies go into receivership. You are likely to have many companies go into insolvency. And as they do, complex issues will be thrown up. So I will look at, go to the next slide, which is the insolvency. I look at how the insolvency has been defined, which is under section 868. But the Registrar General has defined has done a very good job of that, who's an insolvency practitioner and what is required of him and all of that. So I'm just going to skip that bit of the paper. I will look at, in looking at receivership and liquidation, I'll look at section 868 that defines a receiver as a manager or a receiver manager. Then you look at section 556 subsection 1, 556 subsection 2, and which dovetails into the duties of the receiver manager. Now, the duties of the receiver manager, I'm almost certain that I don't want to just bore all of us. We are familiar with them. You will find them in the schedule. So you will find all the duties, and by that you can be guided by section 233 subsection 3, section 55 subsection 553, section 559 subsection 1, 559 subsection 2, 561 subsection 1, 555 section 562, and then you go comprehensively into the 11th schedule. And that gives you the array of what you need to know about insolvency, what you need to know about the powers. Now, let me pause here to say that the schedule, if we take a cursory look at it, enormous powers are donated, is donated. Enormous. Is donated to the receiver. And those powers, you need to caution yourself that at the end of the day, you will be accountable. You will file returns. You have decisions to make. For example, let me just glance through some of those powers. By virtue of the 11th schedule, the power of the receiver are lighted, collect, get into the property of the company, take possession of it, power to sell, power to dispose of the property of the company, power to raise and borrow money and grant security thereof over the property of the company, power to appoint solicitor, accountant, professionally qualified persons. Now, let me pause here. The Act recognizes the fact that as a receiver, you do not know it all. And it's not humanly possible for you to function in that office, to be the accountant, to be the lawyer. So what happens is the Act donates powers to you as a receiver to appoint lawyers, to appoint accountants. I will give a personal, I have an array of consultants, security consultants, financial consultants, and I have a portal where will be prospective interested members of the public will register if there is a need or a sector that they want to venture into. And the importance of that is that so that when a company either comes into my hand and I upload it into the portal, within a number of weeks, it's gone. Because I have people who have already pre-registered for those in those lines. So those powers under the 11th schedule, they're no ones. I mean, they're just there for you and I to look at. So I will look at who is a liquidator. Then a liquidator, of course, you know, is a person that has been appointed to wind up the company. I do not need to say that, whereas the receiver manager, a receiver receives. He sells, he receives, process of sale. And that is where the word receiver is taken from. On the other hand, you made your deed of appointment maybe comprehensive enough to accommodate receiver manager. Then it gives you the latitude you want to manage. Again, I have a lot of management companies that I have managed an hospital before. I have managed oil tank before. I have managed so many things. Why do you need to manage? Sometimes you can have the milk without killing the cow. So you elect to manage. So, and for you to manage, you need to first know that the ultimate responsibility comes to you. So you want to have, beforehand, qualified personnel, qualified companies who knows the trade well. And you want to bring them in to manage. On the other hand, like I did say, the liquidator is a corporate undertaker. It gives a decent barrier to the company. I have done liquidation before. I have done scores of receivership also. And then for the duties of the liquidator, you want to look at section 588. You want to look at section 631. You want to look at 634. You want to look at section 592. And now, next slide, which is what are the practical skills of an insolvency practitioner when carrying out his or her duty. Well, it takes you back to the opening of the paper, and which is the quote of Phil Knight, that play by the rules, but be veracious. The comma spells out your duties, your role. Comma also spells out your liability. Once you know that you have to play by those rules, one, if you don't, you have personal liability. And when you have personal liability, and those personal liability can also have a spillover to your appointer. And if your appointer gets sued, I'm not too sure that you are likely to be called in the next time. So it is important that you play by the rules. However, it's important, and perhaps more important, that you are firm and you have a staying power. And that is what I call be veracious, because you are taking over a terrain that definitely you'll be resisted. Definitely. I remember my first experience in insolvency was in 1998. Late BRIPAN International had been appointed receiver manager of BRIPAN by a consortium of banks. And I was loyal to BRIPAN International. And it took us 9 solid hours standoff to take over. I've had many other experiences thereafter. With these little remarks, well, I think I've shared some practical skills. Again, what is more important is that you must realize that you're a bridge between the company and the creditor. You're a bridge in the sense that by the time you hold fiduciary relationship to the company, you also hold your clients' obligations. So you must balance it. So you look at what is best in the interest of the company and also balancing that with the interest of your client who has appointed you. Thank you very much.
I want to thank the Learned Silk for that very interesting discussion on the skills, practical skills for an insolvency practitioner. The Learned Silk has mentioned that practicing insolvency is not for the faint-hearted. So that brings us to the third discussion, which is our expectations on what a professional, the code of conduct or ethics expected from a professional. So if you decide to practice insolvency in Nigeria, what is expected of you as a professional? What are the code of ethics governing you? And the person that will be having that discussion is Mr. Olanipekun Orewale. Mr. Olanipekun Orewale has over 20 years of experience in business restructuring, insolvency, and bankruptcy matters. He renders advisory services to financial institutions, distressed local and multinational companies and government agencies on business restructuring and turnaround, insolvency, mergers and acquisitions, schemes of arrangement and compromise, liquidation, receivership, and bankruptcy. He also advises on compliance with the statutory regulations by the turnaround and insolvency managers. He acts as counsel representing financial institutions, corporate organizations, multinational companies, and government agencies on matters relating to business turnaround, mergers and acquisition, bankruptcy, liquidation and receivership at the High Courts and Appellate Courts in Nigeria. He was appointed by the Presidential Enabling Business Environment Council as the Nigerian lead expert on the reforms of business rescue and insolvency provisions of the Company and Allied Matters Act 2020. Mr. Orewale has attended and delivered seminar papers in local and international conferences on business restructuring and insolvency. He is a fellow of BRIPAN, INSOL International. He's also a member of the Chartered Institute of Arbitrators UK, Nigeria, as well as an active member of the MBA and IBA. So before Mr. Orewale comes on to speak on ethics and conflict of interest, I would please indulge everyone. If you have questions, kindly drop your questions with any of the ushers around so they can pass it down. Then for those online, I would plead that you drop your questions in the chat room. Thank you. So we now welcome Mr. Orewale to give us an insight on the ethics and conflicts of interest of a practitioner. Thank you.
Thank you, the moderator. It's my pleasure to be here this afternoon. And also, I would like to thank the Council of BRIPAN for this opportunity. I'm here to speak on IP, Insolvency Practitioner, Ethics and Conflict of Interest. Where some of us are lawyers, like accountants, and other members of other disciplines. And as such, what I'll be speaking on won't take anyone by surprise. We are familiar with our ethics and conflict of interest. So I will be very brief in the presentation. Then if there are questions, that can be taken during the question and answer session. So the slide, the presentation will be shared. So the first slide. Yeah, conflict of. So you can see it's about the clash. Clash of interest between we, the IPs, as well as our clients, other stakeholders. That is conflict. So then what is conflict of interest? Is a real definition, seeming incompatibility between one's private interest and one's public or fiduciary. And by that, we are saying that as practitioners, we must not allow a situation that we have conflict of interest. In terms of the public conflict of interest, we can see that if we, an IP, being a members of the board of government agencies, and after, our exit, we then find that, there's certain instruction which relate to that public institutions. So we'll be conflicted in the light of our participation as a member of that body. So the second definition is about clash of interest. That is the clash of interest of an IP in the performance of his professional duties to his client and the interest of the client at stake. Then the third definition is a situation in which the concerns or aims of two different parties are incompatible. That is, your own interest, the interest of your clients, the stakeholders, they are incompatible. Then the last one is a situation in which a person in a position to derive personal benefit from action and decision made in the official capacity. And I will elucidate it. If you are a member of a debtor company, or a company that is about to go into rescue or restructuring, a member of the board, you had participated in the deliberation of who the IP will be, and that you had actually influenced certain persons or persons to be appointed as IPs, then in such a situation for benefit, so then you have a conflict when the basis of your participation and the influence of who the IP will be is on the basis of some pecuniary or monetary interest or consideration. So I highlight in the next slide the instances that can create conflict of interest. We all know that it's just a brief summary. So there are the list is not exhaustive, it's not closed. There are certain, instances that can perfectly fit into this. Personal interest could conflict with actions in the workplace. Say, for example, if as a partner in ALEX, we had actually worked in certain insolvency transaction, on behalf of the client, and I've also received a personal instruction independent of the firm, to act against that client. Then there will be conflict of interest. Then you may also, when you see that you are interested in acquiring a property, the subject matter of an instant insolvency proceedings as an IP, then that will create a conflict of interest. So when you receive money meant for the insolvent companies and you fail to remit into the debtor's company's account or into the liquidation account, as the case may be, that will lead to conflict of interest. Then when you secretly, using a family member, have been appointed, if you have been appointed as a restructuring expert, a liquidator, a receiver, and then there are some juicy asset of the company, and you use a relative, a third party, a family member to get an interest for you or to acquire that property, that in the discharge of our duties, we create a conflict of interest. Accepting an insolvency instruction, the performance of which will be incompatible with the previous advice or opinion given in the previous instruction. That also can create it. If you are an expert in insolvency, maybe a foreign client had requested for your expert opinion advice, which you had given, and subsequently you now realize that some party arising from that transaction that approach you to take up an instruction. The consequence of it will be for you to act, contrary to the previous advice which you had given. That we create a conflict of interest. Appearing as counsel in insolvency proceeding, when you appear on behalf of a debtor company, and that you are also a party in that transaction, you are a party in that proceedings, you cannot also do that. So, how can we deal with the conflict of interest? How can an IP deal with that? Full disclosure. You need to let all the stakeholders, the parties, the creditors, your appointer to know that certain circumstances, have created a conflict of interest for me, and as such, you disclose, you get their consent, get their approval. If they elect that, notwithstanding the conflict of interest situation, you can actually act with their consent. So that is permissible. You can do that. Then you decline to act, and that can arise that maybe because of the relationship or the interest which you have gotten as a result of being an insolvency practitioner, the performance of your duties will be colored, your sense of judgment will also be colored, or you will not act in the best interest of the stakeholders, debtor company, because the whole objective of an IP is to pursue the best of the interest for the client, the debtor, or the stakeholders altogether. Then you can decline that instruction if it is a fresh one. If it's an instruction that is ongoing, you can withdraw, from offering that services. Then you can create a wall, the Chinese wall, for some large firms that have different practice area. If a particular practice group or area had worked on particular transaction, maybe providing advisory, banking advisory services, and there is an insolvency arising out of that, you can tell the client, this banking had given provision, given advice on this particular area. So I will create a wall in such a way that, we, the new team now, will not be interfacing, or the previous team in our practice group will not be interfacing with the new team. So that is also allowed. You must disclose that also to the client and get their consent and approval. So I move to ethics. So this slide definition of ethics can be defined as moral principles that govern a person's behavior in the conduct of an activity. This may differ depending on the professions. We have the rules of professional conduct for we, the legal practitioners, who are also IP. So we also have Institute of Chartered Accountants. They have their own rules. Some are spelled out in the IPAN Act, as well as other professional bodies. So professional ethics are principles that govern the behavior of a person or group in a business environment. In summary, professional, the ethics are the rules or the codes of conduct regulating the performance of the professional duties and responsibilities of an IP, with the overriding objective of ensuring that the best interests of the company, the stakeholder, justice, they are served by that rules. So, like values, we can see when we talk of ethics, we are talking about our values and integrities as IP. And at every point in time, you must remind ourselves that these transactions that I'm doing, or the way and manner in which I'm carrying out these transactions, is my integrity, at stake, or have I been acting as a prudent IP? That you must ask yourself when you are carrying out, insolvency assignment. Like value professional ethics provide rules on how an IP should act in the performance of its duties. Ethical principles underpin. They are your principle rules, differ from profession to profession, underpin all professional codes of conduct. So the expectation of an IP. So what are the expectations? We have to act professionally. We must have laws at our fingertips. So, and the best international standards and practices. We must also, in the discharge of our duties, allow that to be the dominant factor. We must also devote your attention, and expertise to the service of your client and in the best interest of the clients and other stakeholders. That is also part of the expectation. You must also consult and engage with your client and all the stakeholders at every stage of the transaction which you are doing. You need to seek clarifications of some issue that you are in doubt, from your appointer or the stakeholders. So again, we must also warn that in every risk, we need to warn our client of any particular risk which is likely to occur in the discharge of our duties as IP. Where necessary, we equally need to seek the consent of the client and all stakeholder. If you are appointed in the restructuring, maybe through the administration, the CVA, you want to sell the asset, you need their consent. You put the price on board in receivership, you need to go back to your appointer to tell them, oh, this kind of asset in this location, or this I'm selling as a bulk asset, and then this is the price, the best we can get in the market. And you must ensure that in that, you are not making any secret profit. So, where permissible, we must also exercise your independent professional judgment to waive or assert a right or position of your client that is inconsistent with the law. If your client is telling you to act in a particular way and you know that to be a violation of the provisions of law, the rules, your professional conduct or ethics, you need to let the client say, I cannot pursue that line of action. Yes, again, as insolvency practitioner, we are vested with total control of the distressed company. We do need to do everything expedient for the management of the affairs, the property that is in administration. Then also, as an IP, we must not give inconsistent professional advice, in two different matters. If you are taking a position as an IP, and there's also similar transaction bordering on the same set of facts, you must not be seen to be inconsistent in the advice or the line you are taking. So, what can create ethical breach? I give some instances. Like I said, in the list is not exhaustive. Breach of the provision, when you breach the provision of CAMA and other regulations, code of conduct, all of them by an RP, that can make you to run foul of your rules of professional conduct. Failure to properly account for all receipts and all asset funds of the distressed company by IP in the cost of discharging your duties. That will also make you to run foul of the law. Payment of distressed company, if you appointed a receiver, and decided to pay some part of your proceed into the company, into the account in receivership or in liquidation, and some part maybe into the account of a third party, using the third party. There's an equitable right of tracing, and once it is traced actually to you, then you can be made to be accountable for that, IP private account. So I refer to a section. So consequences of the breach. We now have, as the RG has said, the Registrar General. The CAMA 2020 provides for qualification, appointment, scope of duties, and consequences of breach of an IP. As an IP, we realize that we must be a fit and proper, a professional before you can be appointed an IP, as Registrar General says. So when you violated your ethical, responsibilities, or you have a conflict of interest, that will make you to be unfit and improper, for the discharge of the assignment which has been entrusted into your hands. And we then see that there can be an invocation of Section 709 of CAMA, whereby the authorization, the license given to you by the commission, can be withdrawn. And before the Registrar General, there's the principles of fair hearing there, or the commission will take that line of action. You must be notified. The allegation against you, it can be from the stakeholders of the company which you are managing or you are appointed as an IP. So, and say this allegation will receive it against you. Give your responses, breach of your ethical responsibility, or you have completed, you've done ABCD, and within 7 particular time frame, you provide your responsibility if it is with eventually leading to the withdrawal of the license given to you by the commission. So you are entitled to make your representation within 7 days, and if you are not satisfied with the decision of the commission, we all know that you have a right. You can approach court by summon, within 21 days of the communication of the decision by the commission to you, to court. And if you are also not satisfied with the decision of the court of first instance, the High Court by summon, the Federal High Court in this instance, you can appeal to the Court of Appeal, and the decision of the Court of Appeal is final on that. So again, we also see that a liquidator who retains amount in excess of either 50,000 as part of the consequences of the breach, or such other amount as the CAC may approve for more than 10 days and fail to satisfy the CAC as to the need for the retention of that amount, if in the course of your duty, that liquidator will have to pay with interest the amount so retained at the rate of 20%, or shall be liable to disallowance part of his remuneration or removal from his office. So the consequences of breach, if you're also an IP and also a legal practitioner cum IP, that you also realize that you have to follow the rules of professional conduct set out in the RPC. If you haven't done that, if you haven't followed violation of your ethical principles and rules, then that can trigger, an action, a discipline against you by the legal practitioner disciplinary committee. So the RC provide rules, I've said it, IP breach the provision, and the consequences of the provision by the LPDC can include suspension for a period of time. It can admonish you, certain grounds or on the basis of certain directions, striking off your name from the role of legal practitioner or any other directives as the LPDC will decide. If you're an accountant also, as also an IP, we also know that the ICAN have their rules of professional conduct, the violation of which some of them are violated, will, trigger, the invocation of punishments against you by the ICAN. ICAN have their own procedure, which are set out in the ICAN Act. We know the panel oversee the professional conduct, the ICAN panel. So, of accountant, we see Section 11 of the ICAN Act. The panel carry out, once there's an allegation against you, the investigation is behavior by an accountant cum IP, and decide if same should be referred to the tribunal set up under the ICAN Act. And once the tribunal hear you, giving you the rules of fair hearing, and order making your representation, and find you guilty, then your name, the consequences of finding you guilty, reprimand, they can order the registrar of ICAN to strike your name off the relevant part of the register. Restoration of name struck off by virtue of that judgment or the order of that tribunal can occur at the direction given by the ICAN Act. So that is the end of the presentation. Thank you for the indulgence.
I think all the speakers deserve another round of applause. As, would I say, simple as this topic may have appeared, it really threw a lot of insight to what stands up against us as practitioners. It's not supposed to be a walk in the park. It means there are things, like the learned Sikh said, it's not for the faint-hearted. So there are things you need to take into consideration before taking on these roles, ensuring that you're not working against ethics and you're not working against your profession. I don't know if we have questions. Please try to put those questions together. The Registrar General, I don't know if he's still on this call, so that he would also answer questions directed for his response. I really want to commend again the speakers for this session. Just as a form of recap, the Registrar General try to throw insight into what is expected as a practitioner, the license, the criteria to obtaining a license. He also threw an insight to the expansion the regulators have given in terms of who can practice as an insolvency practitioner. The learned seal gave an insight as to what is expected of you in exercising those practical skills, what the Act has provided for in terms of the powers being given or bestowed on you to act. And then the last speaker, Mr. Orewale, yes, gave us an insight as to what we should do when exercising that instruction that has been given to you. So you should know when to drop it, you should know when to pick it up. So please, the questions should come in, but I think the first question here would be directed, while we wait for more questions, I would want to direct the first question to the Registrar General, if he's still on this call.
Recording in progress.
Okay, the first question goes to the Registrar General. In sight of Section 708(4) of CAMA, the Commission made reference to withdrawing the license of someone who they find as not a fit and proper person. And most of the lawyers would agree with me that that word fit and proper is peculiar to the lawyers. But as an insolvency practitioner, it's really not open for lawyers alone. So I don't know if the registrar will want to throw a bit of insight to what the regulators would term as fit and proper in the circumstance that would warrant a withdrawal of a practitioner's license. Okay, while we wait for the registrar to come on to give us a response to that question, my next question will be directed at Mr. Olanik Pekun. It says, in the event of a conflict of interest, where the insolvency practitioner finds it necessary to go ahead with the liquidation or winding up of a company, can the court action be instituted directly against the liquidator? I think there's a mic. No, just.
Okay, repeat the question.
In the event of a conflict of interest, where the insolvency practitioner finds it necessary to go ahead with the liquidation or winding up of a company, can the court action be instituted directly against the liquidator?
Well, every one of us, we are accountable for an action. But when you talk about liquidation, we have in segments. So you know that a liquidator is appointed by court in compulsory liquidation. And in voluntary liquidation, the parties are the ones who appoint them. So if the liquidator, in the light of the conflict of interest, there are certain which have mentioned ethical responsibilities, but there's nothing absolutely, prohibiting, an action. Maybe, for example, if he has made a secret profit, he can, by an action, be asked to account for that secret profit which he has made. So effectively, you can actually file an action against the liquidator, depending on the circumstances of the case. So, and again, I've also highlighted some of the statutory, punishments which can be meted out against the liquidator. Thank you.
Thank you. So the next speaker will go to next question will go to Leonard Silk. It says, is there any rule guiding fees payable to the insolvency practitioner? Or put differently, are there rules guiding remuneration payable to a practitioner?
Okay, thank you. Are there any fees? I'm aware that upon being appointed, before you are appointed, issues of fees will have naturally been settled with your appointer. It's not a one-size-fits-all. For example, if the stake is about, let's say 10 billion, your appointer may want to cap your fee between the range of 2% to 5%. If on the other hand, the amount involved or the sum hold or realizable or to be realized ranges between 1 billion and 5 billion. It may be 10%, it may be higher. So there are no hard and fast rule about it. What I do know is sometimes it borders on negotiation and it borders on how you're able to package issues well. I don't know if that satisfies your the inquiry. Thank you.
Thank you. Okay, there's another question. Maybe actually what the person that asked that question wanted from you was to just give us an insight as to what your fees are normally when you practice. And you actually dodged that question.
Hello, the learner SCN has dealt with the matter, depending on the instruction, the complexity, the size of the portfolio of the action will determine. In fact, in some instances, government assignment, after all, one has been privileged to be involved in some of them. It might not even be more than 1%, depending on, and the government will tell you we can't charge more than this. So for that, it's only you decide whether you are taking it or not. So you have that percentage, because if you have a 1% of a transaction, about 100 billion naira, so you realize that it's quite enormous. So the size of, the claim which were maybe liquidation, I know that some of our professionals here were involved in high-profile liquidation, guided liquidation by the federal government, and on the basis of that, you can't, even yourself can't say that for a transaction of a 10 billion, of 100 billion, you want to charge as high as 10%. So, discretion sometimes, prudence, you realize that, okay, even with this, I'm satisfied, depending on the circumstances, the nature of the case, the profile, the complexity, the length of time. These are the guiding principles.
Thank you, Mr. Arewale. Okay, the second question is, under what circumstances can an insolvency practitioner facilitate sales of an asset under receivership without constituting a breach of ethics, as it's understood that the bottom line is to ensure that assets are realized with reasonable time and the creditors are paid? I think that question should be directed to Mr. Arewale, since you spoke on ethics. Do I take it again? Under what circumstance can an insolvency practitioner facilitate the sale of an asset under receivership without constituting a breach of ethics, as it is understood that the bottom line to ensuring assets are realized within reasonable time and the creditors are paid?
All right. When, just like what Lani SCN has said, as a receiver, you have the power to receive the asset of the company and also the power to sell. So you can actually have some parameter, and I have said it, that for every action you take in receivership, in liquidation, your client, your appointer, don't forget that in receivership, a receiver is entitled to act in accordance with the wishes of his appointer. So you have to go back to them. Yes, I have this. It might be people who, don't forget, the Lani SCN has said that it has a website where if you want to apply maybe to sell the asset, you have them. So you will have applied. You go back to them. I have this some of, where the people who want to buy this asset, do you have any objection to me selling to Prof or to me selling to this person? Although it's a member of BRIPAN to which I'm involved. So, you know, and all of that. Once you have carried them, you've disclosed the fact to them. So, and they have approved that fact. I'm not seeing where you have crossed the threshold of, you know, conflict of interest. I will certainly, because they have agreed to your decision. But when you take it, you facilitated it, and you didn't consult and take the consent of your appointer, then you certainly might be crossing the lines. Thank you.
So just an addition to that question, would your position be the same if the parties involved maybe not necessarily had a professional connection, but they belonged to the same social circles or something, association or something?
Forbidding you from selling to somebody if you're a member of Ikoyi Club, the asset of the company which you are. So absolutely, what you need is, like I said, full disclosure. Once you have placed your card face up to your appointer, to the stakeholders, everybody that you consider their participation is necessary. So you have done that. There's nothing. But however, if in the course of that transaction, in the course of your relationship as a member, maybe Prof and I, members of Ikoyi Club, had actually divulged very crucial, confidential information to me, which will influence my sense of judgment, the way and manner in which I'm going to carry out that assignment. Then I should draw the line and decline that instruction. Thank you.
Thank you so much. Okay, our next question is actually going to be directed to the learned Silk and Mr. Orewale, but I would think the learned Silk should take this first. Or should I say no, Mr. Orewale takes this first, then we will get the learned Silk's insights. The question is coming from Mr. Mike Bekoye SAN. Could you please comment on the implication of the Supreme Court's decision in the Onigbongbo case that there is no conflict of interest where in acting, the legal practitioner will not abuse the confidences of the client in a different matter? Could you kindly comment on the implication of the Supreme Court's decision in Onigbongbo's case that there is no conflict of interest where in acting, the legal practitioner will not abuse the confidences of the client in a different matter?
Well, no, an advocate should know the law. In all honesty, I haven't read the decisions of the Supreme Court, so I will defer on this, on any Bobo case, to the view of those who have read that decision. So, you know, for those comments can come. Otherwise, I will have been in a better position to address it.
I don't know if the learned Silk has an idea of that case.
Okay. So, I think before I even before I make comments on that, I want to just make a contribution on the last question, and which is the fact that selling to a one member or the client telling you to sell to a particular person. Now, it is important that we recognize one fact, and that is the fact that you are a bridge between the company and the creditor. The second fact is that you are answerable and you must be able to defend all your actions. The third one is that there are many banana peels in insolvency. Many banana peels in insolvency. As a matter of fact, authority abounds where the creditors who have appointed you insisted that you sell to a particular person. The Supreme Court has set aside the sale. That it was not independent. You must know the law, you must be independent, and you must do your duty fearlessly. So having said that, the second question borders on my role as a lawyer, or the role of a lawyer That's what my brother Stick, Mike Bukwe, has asked. Whether there's conflict of interest, if I've represented the Onigbo family and a branch who have maybe affiliated to them or in one way or the other. You and I know, except I am on your retainership, I am privileged to have worked for all banks in Nigeria, except very few banks, very few, that I consider family. I'll take a matter against you. Except where you have discussed that matter with me. Then by the rules, I am precluded. I cannot accept that instruction. So conflict of interest can't come in. But you haven't discussed the issue with me. No rule says because I've acted for you, I cannot act against you. I may not be able to act against you if for one reason or the other that matter has been discussed with me, either officially or I've had constructive or implied notice of development in that matter. I mean, it goes without saying that you have to decline such instruction. But where, because I have handled this for you before, I cannot come, I can't handle any other matter against you. And that is what the whole principle in the Onigbo case. And I'm happy, it's a very sound decision of the Supreme Court, that there's no conflict of interest. Thank you.
Thank you so much.
I just want you clarification for that. What of if, by virtue of your role in the previous assignment, in the new matter, you may likely be called as a witness, will you still not decline that instruction? There's likelihood maybe in the course of the prosecution of the second matter, there are facts which, were disclosed to the court necessitating that you may likely be called. So, because there's a case in Nigeria which if William did, he sold the property in VI to two different persons. And at a point in a later subsidy, he was called, although he went to court, Ree Williams, so to challenge that. So will it still be the same thing if, by virtue of your role in the previous, you may likely be a witness for either of the parties? Won't there be a conflict of interest?
Okay, so maybe I should just, at the expense of just repeating what I've said, which, to my mind, I believe that these issues are very straightforward. Before you can be called as a witness, you must have participated one way or the other, either constructively or impliedly. You must have come into, or certain information must have come into your possession, either expressly, impliedly, or otherwise, or constructively. You're a professional. So, and that is why when I presented my paper, I took a lot of things for granted because we're all professionals here. So we're just here to rub minds with each other. Mr. Balogun, I do not know it all, so I'm also here to learn. I don't think there is, somebody said, God forbid, a lawyer knows it all. But it's a lawyer who knows where to know it, where to get the law. The thing is so straightforward, and I don't think we should belabor issues on it or time on it. Before I can be called to come and testify, I must have participated. You can't call a person who does not, who hasn't done, who haven't taken any steps. You can't call me. I said, if you want to call me to come and smile to the court and you are still paying my fee, why not? Thank you.
Thank you. Okay, this next question goes to the Learned Silk. It says, I would like to ask if we can differentiate the practical skills required for RAC officers in insolvency. The person went further to explain, does a nominee or administrator require the same skill set than a receiver or a liquidator?
Okay, so quickly, if I understand your question, that whether there is the same skills is required to be a receiver, an administrator, a liquidator. Okay, so who is an administrator? An administrator is the one that has been appointed to come to the rescue, to rescue the company. Basically, that's all. You have been appointed to rescue the company. So you have virtually so much power also. Sometimes, in most cases, you are given 1 year. You can borrow money. You can do so many things that a receiver is able to do. Like I did say also, all those are listed in CAMA 2020. A liquidator is the one that has been appointed to wind up the affairs of the company. Or better put, give a decent burial to the company. End of story. Are they required to have the same skill? It depends on which context you want to examine it. A liquidator comes in, sometimes it may be voluntary liquidation, which is pretty straightforward. You sell, you realize the money, you pay the credit, you pay the shareholders. You look, and you haven't satisfied yourself that there are no conflicts, conflicting issues, or debtors to be paid, and all of that. But in most cases, the liquidator is the one probably appointed by the court, provisional liquidator. And then you now have to look at so many other issues. And I'm saying so many other issues. So many other issues that even you as a receiver will look at. Who do you pay first? Do you pay your creditor, your appointer first? How secure are they? Are they secure creditors? To what extent are they secured? There's so many issues. And this is why knowledge of that industry is very, very important. Knowledge of that industry is very, very important. So, to my mind, I would say it is safe to say that you need practically the same set of skills to be able to function and function effectively as an administrator, as a liquidator, as a receiver, or a receiver manager. Thank you.
Thank you so much, Leonard. So I'm sure we have the Registrar General on this call now, so he could take the questions directed to him.
Yes, thank you. I'm here.
I don't know if you heard the first question or if I should take it again.
No, I have not. Can you repeat the questions, please?
Okay, the first question is actually borders on section 708, subsection 4 of CAMA, where it speaks to the regulators having the power to withdraw a license that has already been authorized. And the description on what would form that decision to withdraw a license is that the person must be a fit and proper person. During this call, the discussions were centered around solicitors, legal practitioners, accountants being those eligible, one of those eligible to obtain a license. And we all know, if we're looking at it from the legal practitioner's perspective, the issue of fit and proper has to do with the description of the LPA. So my question is, or the question going to you is, what is that criteria that the regulators are going to put in perspective in describing who is a fit and proper person?
Thank you for the question. I think we have tried to narrow the scope of who is a fit and proper person to the rules of professional conduct of the respective professions. If you check our regulations, we are clear that if anybody is disqualified by his professional body from practice, that automatically applies. In the first instance, to even qualify to practice as an insolvency practitioner, you must be a lawyer, a chartered accountant, or a member of IPAN or INSOL, or a chartered secretary. If there is any misconduct in relation to your position as a professional, that has to be adjudicated by the relevant disciplinary committees of these bodies. But if there is a report to the commission on any infraction in the course of your conduct as an insolvency practitioner, Ms. Aurelia has said it, the commission will not just come to conclusion without hearing from you. And if from our investigation and from your response, we found that you are actually in breach of your professional duty, we may be forced to suspend you and refer the matter to your professional body. So we'll be dealing hand in hand closely with the relevant professional bodies to avoid a situation where CAC will be accused of acting on its own. I hope this has clarified the issues.
Thank you. Okay, you have another question, and it says, during the presentation, you mentioned that there's an initial payment of 50,000, which will be paid by the insolvency practitioner to be renewed every 2 years at no cost. Then the question goes, would this not amount to double jeopardy against the practitioner having paid to be trained as an insolvency practitioner under a professional body?
Maybe I will ask the person that asked this question. Was the money paid for the training? Was it paid to CAC? Of course, didn't we pay money to be trained as a lawyer? And despite that, every year you have to pay your practicing fee. Maybe you could have concluded that since you have paid to be trained, you have paid the law school, you should be allowed to practice without having to pay practicing fee every year. Initially, our plan was to make this fee payable every 2 years. But based on the feedback from stakeholders, we had to suspend subsequent payment. I made it a one-off fee. So I don't see any double jeopardy there. The first payment, the payment for the training, is not made to CAC. Even when you are accredited as an agent of the CAC, not necessarily as an insolvency practitioner, you have to pay to be accredited. And that is by virtue of you being a lawyer, an accountant, or chartered secretary. Thank you.
Thank you, Registrar. There's another question directed to you. It says, we would like to know if there are any developments in terms of the solvency rules to support the substantive new law.
Yes, we have made some, though not very extensive. The Companies Regulation 2021 has provided on matters relating to accreditation. As I have said during my presentation, we are developing additional rules dealing with issues on administration of the different insolvency resolution options, standard contents of documents and documentations, standard forms for notifications to the Commission, and the curriculum for the specialized training to be rendered by the different professional bodies, and requirement for bond or indemnity from insolvency practitioners. In our tradition, this started from last year. All these draft rules will be exposed to our key stakeholders, particularly BRIPAN, the MBA, the ICAN and ANAN, as well as ICSAN for their comments before we now refer it to the Honorable Minister for approval. And in addition to that, I have also mentioned this, we have written to His Lordship, the Chief Judge of the Federal High Court, to develop rules relating to administration or to review the entire rules on winding up to accommodate company voluntary arrangement and administration, because these were matters that have been introduced by the CAMA 2020. So we're hoping that we'll have our in-house rules by next week, and we'll share it with BRIPAN and other professional bodies for their input. And in our tradition, we are ready to accept any additional input that we consider germane and before the final approval by the Honorable Minister. Thank you.
Thank you, Registrar. So there's another question. It says, I'm not too sure who I want to direct this to, but I think I would want to hear from the learned speaker, Mr. Orewale. Can an insurance policy cover be employed concerning negligence as a liquidator, a receiver, or a manager? I don't know who would want to go with that question.
Okay, so can insurance policy be employed? The simple answer to that is yes. I'm not too sure that many of us know that you are required to practice law in some other clime, or you cannot practice in some other clime without indemnity insurance as a professional, as a lawyer. You cannot. But in Nigeria, it's not compulsory. So, playing by the rules, knowing the rules, knowing that there are a lot of banana peels, it's only prudent that you take an insurance cover that covers you. Sometimes you may consider the premium paid to be a waste, but it isn't. You may not know when it may come handy, but I will recommend that you have insurance cover. I have always had insurance cover, always. And they are factored into the fees. So, for example, and I've never, the insurance company have never been called upon because there has never been any petition. Well, I'm humbled to say that there has never been any petition against me because I play by the rules. Thank you.
Sir, would your answer be different if it is clear that the practitioner was negligent?
Now, that is in the domain of the contract of indemnity. Some insurance company may shy away and may expressly deny liability for your negligent act. Some negligence may be innocence. Some negligent action may have been committed innocently, albeit negligently. Albeit negligently. So, the hallmark of denial of liability that is universal is where you have made secret profits for yourself. knowingly making secret profit for yourself. Some things we hear, and it's just part of being a human being to hear. So, if you put it on a scale of, oh, who is negligent, who is not negligent, if certain factors or certain knowledge or certain information aren't or weren't at my disposal as at the time of the act, to you it will appear, or to people it will appear that the person has been negligent. But you can only do put in your best. Okay, for example, if a receiver manager, you have a portfolio of, let me say, 200 companies. 200 companies that you are a receiver manager of. Okay, one is in and scattered all over Nigeria. It is not possible that you will be in those locations at all times. You will need to appoint people whose report you must believe, and you must be able to, even though their actions are your actions. So if you talk about negligent conduct, it depends on, so these are issues, and it's good that, it's a very good question. These are issues that you take up with your insurance company. Because it's not possible for you to be everywhere. It is humanly not possible for you to be everywhere. You're a lawyer, you go to court every day, you happen to be the receiver manager for ABZ, and so you can only rely on people. And so once you have taken, you know, it's closing your eyes, seeing things unfolding, and then you're able to bring in those things into negotiation at the relevant time and agree on them. So meaning that insurance companies shouldn't just present you with an agreement and you sign. There must be negotiation. And you must bear in mind that everything is negotiable. Everything is negotiable. The only thing that is not negotiable is you can't go to heaven without Christ.
Thank you, Leonard. I don't know if Mr. Raleigh has anything to add.
Nothing useful to add, except for the fact that the dynamics of the instruction, high-profile instruction now, is that client will require indemnity, professional indemnity cover, for negligence. If sometimes up to a particular sum from you before they can actually give you that instruction, just to allude to what the learned SCN has said. It's a new, and most of the firms now, you now have, professional indemnity cover for negligence, for staff, for everything. We have it in our office. So, and I know that some client will tell you, even if it is not up to a particular sum from high profile, please go and jack it up. So.
Thank you, Mr. Rewale. Okay, this next question actually goes to Leonard Silk, and it's actually a very practical one. So we just need your insight on this. What option is open to an appointer whose appointee is acting against his interest? So you've appointed someone to act, a professional to act for you, and you're finding out that he's not acting in your best interest. Maybe not expected. We may not be talking about ethics now. We may be talking about capacity.
I think to my mind that is very straightforward, because if you have the power to appoint, you have the power to remove. I mean, that is, if you have the power to appoint, you have the power to suspend. If you have the power to, I mean, that is pretty very straightforward. Perhaps the other one that you may even see in practice is where your appointer sometimes acts against you. You, the receiver, your appointer. And we've seen that, okay, you have a consortium of banks. They've appointed, they came together, and you are the preferred person to be appointed the receiver. But the charge, they've surrendered their rights to a trustee. In many cases, the company normally appoints the trustee. So you find that the trustee is in bed with the company. Some trustees are very professional, extremely professional in their conduct, but you also will find some trustee. They will be the one to delay the instrumentality of your appointment and alert the company. You know, I've been privileged to see this, I'll call it shameful or unprofessional act. I know of, I will, for one reason or the other, I won't mention their name. They will be your appointer. They will be the one to alert the company that you are coming. Because in the process of their own appointment, the company has played a pivotal role. So you will need a lot of skill to navigate it and to navigate it well. So the first one is so straightforward. I'm the one who have appointed you. I can remove you right there and there because I have that power to appoint and to terminate or remove you. Thank you.
Thank you. Please, I don't know if we have any comments from the audience or addition. Thank you.
Here you go, sir.
Mr. Balogun, I like the fact you are smiling.
I am smiling when you have my brother's sake that want to ask me a question. So I am smiling because the question that he's going to ask will be the one to answer it.
Right, I wanted to comment on 3 points that arose in the course of the 2 presentations. The first is, Mr. Balogun, you said the skill you need as an IP insolvency practitioner is to be ferocious. And I think to an extent, people who have done receivership here are familiar with that you need to get mobile police and army and civil defense and so on in order to take possession. So to that extent, I think that is probably right. But given also I think the follow-up question they asked you, which is, are those skills different for an administrator, a supervisor of a CVA, a liquidator? And you said there were similar skills. But in the context of those other insolvency proceedings, the challenges appear to be different. As you acknowledge, for example, in the case of an administrator, you might be appointed by the company or by the court, in which case there is no necessarily conflict between you and the management, which would have generated the normal anxieties that would require the intervention of mobile police. So perhaps for the benefit of young ones who would like to become insolvency practitioners, you must know that if you are gentle and soft-spoken, that there is some scope for you to act as an insolvency practitioner, and that you don't need to be a thug, you don't need to enlist the police, and that you just need mild skills to succeed as an insolvency practitioner. My second comment is in relation to a question that was asked about negligence and indemnity cover. In my own experience, the sole reason for taking insurance is for negligence. So every professional policy must cover negligence. That's the reason why people take, because we can all get it wrong. So that policy must be available to protect you in case of negligence. What most professional indemnity insurance policies do is to exclude fraud, which Mr. Balogun also referred to like secret profit. But it's not just secret profit. It's also IPs running away with the estate, or trying to support extended family or other friends through the estate. And finally, in the context of possible conflict of interest, you were asked, what if you were to act contrary to the interests of your appointer? And you said that the power to hire includes the power to suspend and to fire. And I don't agree, because I think in many cases where you've been appointed, you have some insulation from your appointer. For example, if you're appointed as an administrator, you can only be removed by court. The directors who appointed you cannot pass a resolution and say, we are going to remove you because you did not obey us. So to an extent, your position becomes insulated. And even in the case of a liquidator, yes, there is some limited scope in the context of voluntary liquidations to go back and say you want to remove a liquidator. But in the case of a compulsory, you cannot, because a compulsory liquidator, like an administrator, is an officer of a court, and you're answerable to the court. And often, of necessity, you must act contrary to the interests of a person who appointed you. So those type of conflicts are, to an extent, inevitable. Someone might say to you, in a pre-pack, we've arranged someone who will buy. And you know they're just using you to rubber stamp. But you know that if you advertise the assets, you might get a higher price. And you are therefore duty-bound to advertise the asset, at least to expose the asset to a wider market, so as to see whether you discharge your obligation as an IP to get the best price reasonably obtainable. In that context, obviously you'll be acting against the interests of your appointer, but you are not appointed to protect such personal interests which are contrary to law. Thank you very much.
Okay, so I remember that I said for the big masquerade to ask question, he must provide the answer. And truly, truly has provided all the answer. Now, let me just share this with us. Nigeria is a peculiar clime. When you are appointed an administrator, for example, in England, where my brother Silk has made so much money before he joined us, you just walked straight with your briefcase into the company. As a matter of fact, they'll be waiting for you. And that is the truth. And he will bear me witness to that. They'll be waiting for you. But woe betides you in Nigeria, where even where you have been appointed administrator by the court and you're working, I remember that it's a particular company. I was privileged to have been appointed by First Bank. I'm not going to mention the name of the company now. And they said, no, it's a family affair. There should be no issues and what have you. And then it was just from experience. And then I had the court order. And then we went to take over. The policemen were beaten to stupor. They had to call for reinforcement. And that's the Nigerian market for you. That's the Nigerian market for you. So it was after the call for reinforcement that we were able to take over. I mean, there are so many issues. We take over, it's, I can't even, my brother Silk is very soft-spoken. And I'm also very soft-spoken. Very, very. I'm very soft-spoken. Can't even bite a fly. But you must know that the Nigerian market is peculiar, very, very peculiar. It's only in this country that people will hold, and they will be the one to run to court and fight you. They will be the one to run to court and get an order against you. And that is the climb that we operate. And so you must be, like the Boy Scout, be prepared. Thank you.
Thank you. The Leonard Silk wants. Mr. Yekwazu. Leonard Silk Yekwazu. CVC.
Thank you very much, and thank you, distinguished panelists. Very briefly, my concern is that in view of the revelations in these presentations, particularly with the learner's sake, now talking about the Nigerian factor, the peculiarities that affect our own regime in insolvency. What role should the judiciary play? Because we notice that in most cases, even where the courts provide for directive and protective orders, sometimes you still need some extra skill to effectively discharge some of these assignments. So I would like the panelists, the presenters, if anyone can suggest, because the judiciary as an institution that regulates the insolvency regime to a great extent has some role to play. If the provisions of the law are not adequate enough to ensure that these processes are conducted in a way that it will be very smooth, just to use the word, do we need some level of amendment with regards to the law or some improvement in terms of the practice standards that operates in Nigeria? Thank you very much.
Okay, so do we need amendments? Maybe, maybe not. A receiver manager that's been appointed out of court, you have power to approach the court for so many things, for so many determination of any questions. But before then, you also want to approach the court to have protective order, which I would say is also, recognizing the Nigerian factor. It is clear that this particular company had been availed depositors' funds. It is clear that there has been a default. It is clear that you have been appointed. It is clear that you have fulfilled crossing the T's and dotting the I's with CSC. And then you are before the court. I remember one or two judges, one particularly will say to me, Mr. Walogun, I don't grant ex parte. And then I'm going to direct that you put them on notice. And this is a very erudite, very brilliant judge. Very, very brilliant judge. So I was on my feet for ordinary ex parte application for 4 good hours. And I had to break the issues down, one after the other. And at the end of the day, he granted it. Some may tell you they don't. you are likely to now face, and your role as a practitioner is to allow the court to see the enormous damage that will have been occasioned if you were to put the company on notice. As a matter of fact, it runs contrary to the spirit of the law. Why? Because Kama says upon your appointment, all the assets become vested in your person. So, is there need for amendments? To my mind, I would say that the laws are adequate. The interpreters of the law, there may be patience or skill required of you as a practitioner to break this thing down, because sometimes you assume that he knows it, or the law resides in the bosom of the court. So you may have to break this thing down and let the court see that for a simple commercial transactions, once there has been a default, this is just the application there is innocuous because there has been a default. And in many cases, they are documentary. You can see letters that have been written, a demand has been made, that demand has been ignored, or sometimes you can see acknowledgement of the indebtedness and what have you. So you may, I will always advise that be calm, be cool, calm, and collected, and take the court through every point and let the court see the reason why it must rule or it must give you the order you need. I must also say that perhaps what you are trying to say is that there appears to be a lacuna, because Professor Odita I will invite Professor Odita to throw more light on this, because nobody knows it all. I am yet to see a clear provisions that allows you to come to court ex parte. So the court says that, even if it's ex parte, the court still has discretion, and that discretion is to be exercised judicially and judicially. But even in the absence of such, it's very, very straightforward that the risk, in fact, all the case law, the analysis is that the risk of dissipation and secrecy, urgency, that is all the case law. That secrecy, urgency. So those case law are the one that comes to you, to your head, to use